This is Paul. Yes. Just getting back to these requirements, right? I think the summons and petition were mailed pursuant to an order for service by mail. Did the court commissioner order service by mail? Yes. And was there any proof of that? Oh. Now, not having signatures on the protection order violates the requirements for a judge or court commissioner to be able to sign it? Yes. The petitioner didn't sign the protection order. The protected person didn't sign the order. There are forgeries. I'm pretty sure this signature, yes, is not the same as this signature. Yes. And it's not the same as that signature. Could be that my public defender that fucked over all of those in the dog family. Yes. Doesn't realize that Exhibit A is not an actual copy of what was served on me. Oh. Now, we could have had a mistrial a long time ago, couldn't we? Yes. Now, the opposing party, within 10 days after receipt of the motion, file and serve on the moving party and the judge or commissioner making the ruling pleading documents in opposition. If you don't actually serve me, I can't within 10 days of receipt of the motion. Yeah. Now, I know, read the rules really close, okay? Every judge in the United States, check me on this, okay? But if I, as the opposing party, known as the respondent, yes, does not get any notice of court hearings, no matter if it's 10 days, 5 days, 2 days, or 4 days, or 6 days, or 8 days, or 9 days, or 1 day, yes, I cannot file and serve the petitioner or the judge and commissioner making the ruling, pleading documents in opposition. Yeah. See, without actual receipt of the motion, it doesn't fucking matter how many days it is. Now, I know you thought that it was wrong. You were always thinking, well, all these different days, 12 days, 14 days, 5 days, 7 days, but not having any actual notice, yes, makes it difficult because I don't have any number of days as the opposing party, yes. Within 10 days after receipt of the motion, as in being served, yes, yes, to file and serve on the moving party known as the petitioner, yeah. The judge or commissioner making the ruling, pleading documents. I was not served during the dissolution of marriage, and that violated my right to serve the moving party. Now, these domestic relations settlement conferences, yes, I wasn't invited to any of those. I'm wanting to have custody of my sons, and it seems like some judges would rather bet on the outcome of me getting my rights enforced instead of enforcing the law. Notice for trial setting, settlement conference setting, 9/14 of 2012. Yes. Now we went through this. This was on 9/4. Yeah. 10 days. Yeah. 9/4. There was a declaration, proposed parenting plan, child support trial, motion, affidavit, declaration for temporary order. Yes. And then on 9/14, you had a settlement conference setting action. Now, these trial setting, settlement conference setting, and then settlement conference setting, a settlement conference, yes. These domestic relations settlement conferences, it says here in one of those, it could be Lewis or it could be Clark, yeah. In all domestic relations matters involving children, settlement conferences are mandatory. As in the individual known as the respondent, the father of 5 sons, yeah, one of the parties, the presence of the parties and counsels is mandatory unless excused by the court. Oh. Now, if a party fails to attend the mandatory settlement conference, the settlement commissioner may strike the trial date. That was the word, striking it, stricken from the court. The attending party would then be able to move for an order of default and for terms. Yes. Now, what excuse was given that I wasn't there? Brent. And why wasn't it an order for default filed then? Each party shall provide. Now, I should have had to provide some sort of proposed parenting plan, and pre-trial affidavits are required. If child support or payment for daycare is an issue, both parties shall provide their set of Washington State child support schedule worksheets. Should have got some worksheets before you had that. Additionally, each parent, known as Paul and Heidi Budnick, shall provide federal income tax returns for the past 3 years. Did she provide her tax returns because my name would have been on them? Yes. Now, it was in 2012. She probably didn't make a lot of money. Then wage and hour payroll statements for the previous 3 months. As I remember it, she was on welfare. I was homeless. Yes. No, I was living in a fifth wheel doing volunteer work at Kingsway Foursquare Church. Yeah. And you decided that I had to pay twice as much as she did when the last 3 years of income taxes would have been our joint tax return? Yes. Documents establishing medical and or dental insurance on the children. We actually didn't have any medical or dental. Yes. She probably got some when she got to Clallam County. Now let's see, we were on welfare on Guam. Yes. But well, if we were joint filers on the 3 years of tax returns and we didn't make any money in 2010, yeah. 2011, yeah. And 2009 was a tough year. You remember the foreclosure? Yes. How the fuck is it that you calculated that I owe twice as much? Uh, how did you come about that number? I did read the original dissolution of marriage that was served on me when I was arrested. Yeah. But I wasn't served mandatory notice of settlement conference hearings, and I wasn't allowed to participate in any of those. And what I did read was you wanted me to pay twice as much because of the amount of money I made from 1999 to 2007. Yeah. Now, just so I know, Judge, how the fuck is it that you made me pay $1,500 a month? You had the joint filing return, right? Never served a dissolution of marriage. Oh. Now, I thought this was really good. Yes. The failure to appear, if the party noting a motion fails to appear for the scheduled hearing, and the opposing party appears, the motion shall be not denied or stricken. That's the word, denied. You know, every time you did not give me notice in hearing, you did not give me the opportunity to appear in court when the petitioner hadn't appeared in court. Do you think I would have liked it if you had denied her request to issue a fucking protection order? Oh my gosh, look at that. As we go through each and every one of these motions.